I have been called many things from this bench: unfair, biased, too harsh, too lenient. I have had defendants tell me I didn't understand the real world, and plaintiffs tell me I was protecting the powerful, and attorneys tell me, in the carefully worded language of legal objection, that I had no idea what I was doing. In 40 years, I have heard all of it, and I have learned to receive most of it with equanimity because it comes with the job, and most of it says more about the speaker's frustration than about anything I have actually done. But there is one thing I have learned to watch for more than any other: certainty without basis. The man who knows he is right before he has looked at all of the facts. The person who is so confident in their conclusion that they have stopped asking questions that might complicate it. The CEO who sits in a courtroom and calls another person a liar and does not realize yet that the word liar is a claim that requires evidence and that the evidence he has brought does not contain the one thing that would make it true. That is what I saw on the morning of November 4th, and by the time I asked one question, one sentence, 11 words, a man worth $40 million had nothing left to say. Stay with me. I want to tell you exactly how it happened, because the question was simple. It was so simple that you are going to wonder why no one asked it before I did. And the answer to that question, the reason no one asked it, is the whole of this story. The plaintiff was a man named Joseph Reeves. He was 58 years old. He had been living without permanent housing for 3 years, shelter when there was space, tent encampment near the river when there was not, and the covered entrance of a parking structure on Clement Street on the nights when neither was available. He arrived in my courtroom in clean clothes and with a folder organized into 4 sections and a phone whose screen had a crack across the lower right corner that he had covered with a strip of clear tape. He had spent most of his adult life in warehouse logistics, inventory management, receiving coordination, the methodical, unglamorous, genuinely skilled work of tracking where things are and making sure they get to where they need to be. He had been a line worker, then a lead, then a supervisor. He had managed teams of 12. He had been, by every professional measure available to him, good at his work. In 2019, the company he had worked for 9 years automated his department. 31 people were let go in a single afternoon. Joseph had been among them. What followed was the sequence that follows for a certain kind of person when the floor drops out. Not a catastrophic fall, but a slow, grinding descent, each step down making the next one more likely. He had tried to find comparable work. He had taken a back injury during a temporary loading job that put him out for 4 months. The savings went during those 4 months. The apartment went when the savings ran out. The storage unit went when the apartment was gone and he could no longer cover the monthly fee. The storage facility auctioned the contents, his tools, his records, his furniture, the physical evidence of 22 years of professional life, and sent the final notice to an address that was no longer his. He had been trying to get back for 3 years. I want to be precise about that word, trying. He was not waiting. He had a phone he charged at the public library. He had a bus pass obtained through a workforce services nonprofit. He had a resume on a thumb drive that he updated regularly at the library's computers, a resume that reflected accurately and without embellishment 22 years of logistics experience that was, for any employer willing to look past the employment gap, genuinely valuable. In 3 years, he had been given a serious look by one employer. That employer was Harlan Distribution Services, a regional logistics operation, 30 trucks, mid-8-figure annual revenue, founded and run by a man named Craig Weston. Weston was 51. He had started the company at 28 with 1 truck, 1 contract, and a client list written on a legal pad, and he had built it into something real through 2 decades of long hours and fast decisions and the particular willingness to bet on himself that produces either a company or a bankruptcy, and had, in his case, produced a company. He was, by his own account and by the account of anyone in the regional logistics industry who knew him, demanding, decisive, and not easily contradicted. Joseph Reeves had been hired by Harlan in January. He had worked there for 4 months. He had been terminated on a Thursday morning in May. The termination letter used the word theft. Joseph was suing for wrongful termination, back wages, and defamation, specifically the use of that word in an employment record that had been following him since May, He was representing himself. He had a folder and a phone with a cracked screen. Craig Weston had 2 attorneys from a firm that specialized in employment defense. I called the case and asked Joseph to present his claim. He stood. He was a tall man, thin in the way that people become thin when meals are uncertain, but he carried himself with the posture of someone who had not yet accepted that circumstances defined him. He spoke clearly and in order. He said he had been hired as a logistics coordinator in January. He had been given access to the company's inventory management system, a role he was well qualified for. For 4 months, he had performed his duties without incident. His supervisor and a woman named Diane Park had told him twice during that period that his work was strong. In May, he had been called into a meeting with Craig Weston directly. He had been told that inventory discrepancies had been discovered and that the investigation had identified him as responsible. He had been terminated on the spot. The termination letter, which he had kept, used the word theft. He said, "I did not steal anything. I have never stolen anything in my life. I am here because that letter has followed me. Every employer I contact, if they check references, they reach Harland. I do not know exactly what is said, but I know the result. In the 14 months since my termination, I have applied for 41 positions for which I am qualified. I've received 3 interviews. All 3 ended after the reference check." He placed his termination letter on the table. He placed his phone beside it, open to a screenshot. He said, "This is a message from Diane Park sent to me 6 weeks after I was fired. I am going to read it to you. It says, 'Joseph, I want you to know I don't believe what they said. The numbers didn't add up before you got there, and they don't add up now. I'm sorry. I hope you land somewhere good.'" He looked at me. He said, "That is all I have. I know it is not much, but I am here because I do not know what else to do." I looked at the phone. I looked at the termination letter. I looked at Joseph Reeves, who had gotten himself to a courthouse with a phone and a folder and a screenshot of a text message to fight a termination that had effectively closed every professional door he had tried to open for over a year. I said, "Thank you, Mr. Reeves. Let's hear from the defense." Craig Weston's lead attorney, a woman named Sandra Cho, rose and presented the company's position efficiently. She was experienced and clear. There had been a genuine inventory discrepancy. That much was not in dispute. An internal audit conducted by an external firm had identified irregularities in 3 product categories during the period of Joseph's employment. The audit had cross-referenced access logs with inventory records and had identified Joseph Reeves as the employee with the most direct access to the affected categories during the relevant period. The company had terminated him on that basis. She submitted the audit report. It was professionally prepared, 31 pages, organized with appendices. I reviewed it carefully. I read the methodology section twice. Then I looked at Craig Weston. He had been sitting at the defendant's table with the composed authority of a man who has spent 20 years making decisions and having them respected. Well-fitted jacket, notepad, occasional notes written in the manner of someone who documents everything as a matter of professional habit. He looked like what he was, a man who had built something from nothing and was accustomed to being the most certain person in any room he entered. I said, "Mr. Weston, I would like to hear from you directly about the decision to terminate Mr. Reeves." He looked at Sandra Cho. She gave a small nod. He stood. He was not nervous. I want to be clear about that. He was not defensive. He spoke with the fluency of someone who had reviewed his position and found it sound. The audit had been conducted properly. The access logs were unambiguous. The inventory categories in question had been under Joseph's direct oversight. The timeline aligned. He said all of this correctly and confidently. And then, without being asked, without any particular prompt beyond the fact that Joseph Reeves was sitting 10 feet away having just told his version of events, Craig Weston did something that told me everything I needed to know about how this termination had happened. He said, "Your Honor, I want to be straightforward with you. This man is lying. He stole from my company, and he is here today attempting to profit from that theft. I have 31 pages of documentation. He has a text message from a former employee." He sat down. The courtroom was completely still. Joseph Reeves did not react. He sat with his hands on the table, and he looked at the front of the room with the practiced stillness of a man who had heard versions of this for 14 months and had learned through repetition and necessity not to respond to it in rooms where responding would cost him. The courtroom was very quiet. Joseph Reeves did not react. He sat with his hands on the table and he looked at the front of the room. He had, I understood, heard versions of this for 14 months. He had learned not to react. I looked at Craig Weston for a long moment. Then I asked my question, one sentence. I said, Mr. Weston, what were the inventory numbers in those same categories in the 3 months before Mr. Reeves was hired? Craig Weston looked at me. He looked at Sandra Cho. She was looking at her binder. He said, the audit covered the period of his employment. I said, I understand what the audit covered. I am asking about the period before his employment, the 3 months prior. What were the inventory numbers in those categories during that period? He said, I don't have those figures in front of me. I said, did you look at them before you terminated Mr. Reeves? He said, the audit was focused on the relevant period. I said, Mr. Weston, yes or no? Before you terminated this man and put the word theft in his employment record, did you or anyone at your company look at the inventory numbers in those same categories for the period before he worked there? The silence that followed lasted approximately 8 seconds. 8 seconds is a long time in a courtroom. Sandra Cho was very still. Craig Weston said, the audit methodology was, I said, that is not a yes or no. I am going to ask one more time. Did anyone at Harlan Distribution Services examine the inventory figures for those categories in the period before Joseph Reeves was employed there? He said, I believe the audit was comprehensive. I said, Counselor. Sandra Cho stood immediately. She said, Your Honor, I would need a brief recess to consult with my client on the scope of the audit methodology. I said, you may have 10 minutes. They took 9. When they returned, Sandra Cho's posture had changed in the way that attorneys' postures change when they have spent 9 minutes learning something they did not previously know, and that changes the shape of what they have been arguing. She said, Your Honor, upon further review, the audit did not include a comparative baseline analysis of the pre-employment inventory figures. I said, so the answer is no. She said, correct, Your Honor. I said, so Harlan Distribution Services identified inventory discrepancies during Mr. Reeves's employment, attributed those discrepancies to Mr. Reeves, terminated him for theft, and put that word in his employment record without ever checking whether those same discrepancies existed before he arrived. She said the audit was focused on the period in question. I said, the period in question is meaningless without a baseline. You cannot identify a discrepancy without knowing what the numbers were before. That is not an audit methodology question. That is elementary logic. I looked at Craig Weston. He was looking at the table. I want you to understand something about that moment, about what type justice in the comments right now if you believe that a man's livelihood should not be destroyed without basic due diligence. And while you are down there, subscribe to this channel, because what I am about to tell you about Diane Park's message and what it actually meant is the thing that completed this case. Because here is what the audit had not found and what Joseph's screenshot had pointed toward without either of us fully realizing it at the time. The inventory discrepancies had existed before Joseph Reeves walked through the door. I requested the pre-employment inventory records from Harlan's own system, the same system the audit had accessed, simply looking at an earlier date range. Joseph's attorney of record was himself, so I was careful to work through proper channels. The records took 3 days to obtain. When they came back, they showed discrepancies in the same categories at comparable levels in the 2 months before Joseph's first day of work. The problem had not been caused by Joseph Reeves. Joseph Reeves had been the most recent employee with access when someone finally noticed the problem, and Craig Weston had concluded, without checking the baseline, without asking whether the problem predated the hire, without doing the one thing that basic fairness required, that the most recent person with access was the responsible party. He had put the word theft in a man's employment record. He had effectively closed 41 doors in 14 months. He had done it without checking. I ruled. The termination was wrongful. The audit, I found, had not established a sufficient evidentiary basis for the conclusion it reached, specifically because it had not examined baseline inventory data from the period before Joseph's employment. A discrepancy identified during someone's tenure, without comparison to prior periods, proves only that a discrepancy exists. It does not identify cause. It does not identify responsibility. Using such an audit as the sole basis for a theft accusation in an employment record failed the standard of care that a reasonable employer is expected to apply before making that specific and consequential characterization. The defamation claim was sustained. The use of the word theft, not misconduct, not policy violation, not performance issue, but theft, in an employment record without adequate evidentiary foundation, and in the context of a reference process that Joseph had documented as actively closing employment opportunities, constituted actionable harm. Back wages for 4 months. Compensatory damages for 14 months of documented employment loss, the applications, the interviews, the reference checks that ended them, all of it in Joseph's carefully organized folder. The total reflected the cost of what had been done, not a punishment for doing it, which is a distinction I observed carefully, and I ordered, this was not negotiable, Harlan Distribution Services to issue a corrected employment letter to Joseph Reeves within 10 days. The letter was to state explicitly that the theft characterization in his termination letter had been issued in error, that the internal audit on which it was based had been found to be methodologically insufficient, and that Joseph Reeves's employment record contained no findings of misconduct. That letter was the thing, not the money. The money mattered, and I want to be clear that it mattered, but the letter was the key. 14 months of closed doors, and now a document that would open them again, a correction to the record, the truth finally in writing from the source of the lie. Before I struck the gavel, I addressed Craig Weston directly. I said, "You called this man a liar in open court this morning. I want you to understand what that word has done. In 14 months, Mr. Reeves applied for 41 positions for which he was qualified, 3 interviews. All 3 ended after the reference check. That is what the word theft in an employment record does to a person. It follows them. It closes rooms before they can enter them. It tells every future employer a story about who this person is. And in this case, that story was not investigated before it was written. I said, you had access to the same inventory system before you made your decision. You had the ability to look at the numbers from the prior period. You did not look. You saw a discrepancy. You identified the most recent person with access, and you used the most damaging word available in an employment termination. And then you came into this courtroom and called him a liar. I said, Mr. Reeves is not a liar. He is a man who lost his job, his housing, and 3 years of his professional life because you did not check. I struck the gavel. Craig Weston left without speaking. His attorneys gathered their materials efficiently and followed. Joseph Reeves sat for a moment at his table. The room had cleared quickly. Weston and his attorneys were efficient about leaving. The gallery thinned. My clerk began gathering the case file. Joseph did not move immediately. He sat with his hands on the table, and then after a moment, he picked up his phone, the one with the cracked screen, the strip of clear tape across the lower right corner, and he looked at the screenshot of Diane Park's message. He had shown it to me 2 hours earlier as his primary evidence. He had identified it himself as not much. He had brought it because it was true and because it was what he had and because he did not know what else to do. He looked at it for a moment, then he put it in his pocket. Then he picked up his folder with its 4 organized sections. Then he stood. He looked at me briefly, not with triumph, not with relief exactly, but with something that I recognized as the expression of a man who has been disbelieved for a long time and has just had one room tell him the truth. He nodded once, then he walked out. I have thought about this case many times since November 4th. I think about the 41 applications, the 3 interviews, the reference checks that ended things. I think about what it is to carry a word like theft in your professional record, not as a conviction, not as a proven fact, but as an allegation in a letter that shows up when someone calls for a reference and changes the temperature of every conversation that follows. I think about Craig Weston saying this man is lying, saying it confidently, publicly on the record, without having checked the one thing that would have told him whether he was right, without having asked the one question that would have taken his audit team perhaps an afternoon to answer, without pausing even once to consider whether the problem might have predated the person. That confidence is what stays with me, not malice. I am careful about attributing malice where negligence is the more accurate word. I do not believe Craig Weston woke up on that November morning intending to destroy a man's livelihood. I believe he saw a problem, identified the most available explanation, and moved with the speed and conviction of someone who has spent 20 years building something and has learned that decisiveness is a form of leadership and hesitation is a form of weakness. He had built a 30-truck company from a single truck and a legal pad. He was accustomed to being right. He was wrong. And the cost of being wrong was paid entirely by the person who had nothing to do with the error. That is the specific, quiet violence of power exercised without adequate care. It does not announce itself. It does not feel cruel from the inside. It feels like management. It feels like accountability. It feels like running a tight operation and not tolerating problems. And from the outside, from the position of the person on the receiving end of the decision, it feels like a door closing. And then another, and then 41 doors in 14 months, each one closing after a reference check that takes 10 minutes and carries a word that should never have been written. Joseph Reeves paid for 14 months. He paid with 41 rejections, 3 interviews, 3 years of trying to get back to the professional level where he had functioned successfully for 22 years, blocked at every turn by 4 letters on a piece of company letterhead. Now I need something from you. If you know someone, a neighbor, a family member, anyone, who has been let go from a job on an accusation that was never properly investigated, share this video with them right now, because the question I asked Craig Weston is a question that anyone in that situation can ask. Did you look at the baseline? Did you check the period before? Was the problem actually there before I arrived? Sometimes one question is everything. Subscribe to this channel before you close this page. I am not done. Every week there is another case like this one. Another person sitting across from someone with more resources, more confidence, more certainty, and I am going to keep telling these stories. And leave me a comment. Tell me about a time someone was certain about something and they were wrong. Tell me what happened when the truth came out. I read every single one. Craig Weston came into my courtroom certain. He left without a word. One question. That was all it took.